The United States actually was rather outspoken in, again, during the Bush administration, in favor of letting the prosecutor continue letting the investigation run its course. So there was the interesting spectacle in a way of the United States arguing more strenuously for the continued operation and investigation of the International Criminal Court, and some of the stronger proponents of the court viewing the court more as a means to diplomatic kind of end of trying to obtain a better resolution on the ground. Now, what I think, notwithstanding the Bush administration declared that this was no precedent, this referral to R4, it is exactly a precedent. The day of the Special International Tribunal is over. There won't be any particular need to create an NEP-type tribunal again, and the reason is because we now have a mechanism. We know how to do this through the Security Council. The Security Council can draft resolutions that the United States can allow to go through. I would hope that the next time that this kind of situation arises, the United States would be able actually to vote in favor of it and not just abstain. But we have a functioning court, a court that has a record now of 7 years in operation, and it is it's there and available, and it would be, I think, at a minimum, a waste of resources, and at a maximum, a kind of odd exercise in ideological grandstanding, not to take advantage of it when we need it. And again, I mean, we need it. We need mechanisms for the pursuit of these kinds of perpetrators, and when we do it through the UN, which the court seems to welcome, and when we do it in a fashion that the nationals of non-parties are not put at risk, then we ought to be able to do it in a way in which the United States can be supportive and indeed cooperate with the operation of the court. The way forward from here, I think. The way forward always involves looking backward a little bit, and it's important to understand that the court has been circumspect, has been, rather than being a kind of rogue international institution trying to reshape the global order, it has actually been very focused on its primary mission as a court of last resort. The prosecutor has never used that power to bring a case independently. The situations that he is currently looking at, of which there are 4, the 3 country situations in Central African Republic and Democratic Republic of Congo and Uganda, all are instances in which the countries themselves asked the court to come in order to look at, in order to bring some of these kinds of perpetrators to account. In fact, in one of those cases, the prosecutor had received some information from parties that he told the Assembly of States parties was sufficient to enable him to bring an investigation under his own power, but he said it would be better for the investigation if the country requested the investigation. And in fact, that is what happened. So rather than a kind of a rogue prosecutor, we have a very, I think, a prosecutor who regards the legitimacy of his investigations not as something that is automatically conveyed by the terms of the Rome Treaty, but as something that was the terms of the treaty is something on which to build legitimacy. So I think that's been an important element. The court has also now a record of doing a rather good job in terms of protecting defendants' rights. It's true that there is no right to trial by jury at the International Criminal Court, and there are other ways in which the Rome Statute does not precisely mirror the protections that American citizens feel under the U.S. Constitution. But as Judge Wald also noted, there's no reasonable way of looking at the due process procedures that the court has put in place and reaching the conclusion that these aren't up to some sort of legitimate, fully legitimate standard. And so that area of suspicion about the action of the court is proven to be unfounded. The prosecutor also rather notably declined to take up Iraq. The referral to him suggested this was essentially that mainly pertains to British soldiers, and it was it's actually worth it's worth having a look at in terms of dispelling some of the concerns about an overly ambitious prosecutor. The allegation essentially was that the British soldiers were complicit with American soldiers in the mistreatment of prisoners. Now, this was certainly an effort to invite the prosecutor to somehow consider the possibility of a kind of collateral jurisdiction that would bring Americans into the court. Of course, he rejected that immediately, noting that that Iraq was not a party to the International Criminal Court, and that the United States was not a party to the International Criminal Court, leaving potentially within this jurisdiction only the UK soldiers. But then he noted that while there was indeed evidence of criminal conduct, that it was not of the scale and scope of those other investigations that are currently underway. In other words, that these were smaller scale incidents, which is important in terms of considering this sense of the court as court of last resort and generally going after the worst of the worst. And he said as well that he noted that the UK had conveyed some information to him indicating that investigations were going on. So again, this is this principle of complementarity, that when a local system is capable and willing to deal with allegations of atrocities, atrocity crimes, war crimes, then it is not the place of the International Criminal Court to try to step in. So again, I think it's further illustration of the reasonableness with which the court has approached its business. So I think what we're seeing in general is a court that is overcoming by practice the genuine problems that the United States had with its founding document, the Rome Statute. I won't say that the people will acknowledge that all doubts have been dispelled, but at this point, none of those doubts have been furthered in any instance that has been apparent. And if the court is not altogether, and may never be able to prove that these concerns are unfounded, nevertheless, I think the court has shown that it is willing and able to act reasonably and responsibly in dealing with the situations that come before it. So the way forward, it seems to me, and I agree with the recommendations of the ASIL report, is indeed a policy of cooperation with the court. There are many things, many levels at which we can do things. Certainly, we should be attending the review conference. Certainly, we should be participating in the informal discussions and other working group discussions that go on in New York. These are all instances in which the participation of the United States can take place without cost and without prejudicing the question of whether or not we should actually join this court. The court would welcome, I think, the presence of the United States, and I think the United States would benefit from being present. So this has, I hope, been a very national interest-based kind of case for cooperation with the International Criminal Court. It's not the only kind of case. There is indeed a global architecture kind of set of issues, but those are controversies that we don't need in order to settle the question of whether or not we should be there and whether we should cooperate. So I'll stop there. Thank you.